So is there anything that you don't understand that's going on here today? So instead of giving you 4 years, I could sentence you up to 20 years in the prison. Do you understand?
Yes, ma'am.
Now, this agreement that they've come to, do you want me to follow that? Mariano Rendon? Welcome.
That should say custody. He's not physically here.
Yes, I believe at the last hearing, he gave you
Right.
permission.
Yes, I just want to make sure you knew why he wasn't here.
Yes. He's in custody, correct?
He is in custody. We wanted him released to PDC. We don't, but
Yes.
I think he's still here. I don't think he's been shipped yet.
Not yesterday.
So is he downstairs? All right, they'll bring him up.
Okay. And the other one I have is his son.
Matthew.
Yeah.
Are you taking care of Matthew as well?
Yes.
Adrienne went all the way back to 23 and she couldn't find a brack.
Yeah.
All right, Matthew Rendon,
Yes.
I can't find the brack.
have you conferred with the state? Because we're just here for restitution.
Yes, they haven't had contact with anybody on Matthew's case. That's why I'm not going to be any contact here.
All right, court is calling 2024 CR 2339D, State versus Matthew Rendon. Could I have parties announced for the record?
Duffy Pitlock for the state of Texas.
Raymond Martinez from Mr. Rendon.
Are you Mr. Rendon?
Yes, ma'am.
All right, we're here for a restitution hearing. The defendant entered a plea on June 12th, 2025. He was placed on probation. The court reset this case specifically for a restitution hearing. State, is there any restitution?
As for this defendant, we gave complainant opportunity to provide documentation for restitution. We haven't received any, so the state cannot proceed with restitution as to this defendant.
Here's the first twist. The judge just ruled no restitution for Matthew Rendon. Translation? The victim or complainant didn't submit documentation proving financial loss, so legally the court can't order repayment. This might sound like a win for Matthew, no extra money out of his pocket, but it also shows how critical paperwork is in these hearings. If you're the victim and you don't submit receipts, invoices, or official documentation, the court's hands are tied. What do you think? Should restitution be automatic for victims? Or does the burden of proof make sense here?
Defendant, Your Honor.
All right, and probation, did you receive any restitution amount on Matthew Rendon?
No, Judge. It was, we were under the impression since it was set for a restitution hearing 30 days out that the state would take care of that.
Yes.
We haven't had an opportunity to research that, Judge.
Oh, no, I understand. I was just saying if any complainant called into probation with a restitution amount. All right, the court will order no restitution in this case. Any objections from either side?
None from the state, Your Honor.
No.
All right, then there will be no restitution. All right, thank you.
Thank you, Judge. I guess I'll come back on Mariano if he actually is here.
Yes. Well, do you know if they have restitution?
Counsel informed me that they filed a business records affidavit. I'm trying to track it down to look at the number. I don't anticipate objecting to it. I like to know what the number is before I say I don't object.
All right, so if
So
you'll
I'm trying to
confer with
track
them
it
on
down.
that and we'll bring you right up.
Okay.
Mr. Lemire,
Good morning, Your Honor.
good morning. Oh, where's Mr. Lemire?
He is in the box, Judge, in the box.
Okay. All right, the allegations in the motion to revoke, is that family violence or who is that?
Yes, they're both number ones out of County Court 13. Both of them are still pre-file cases. And so one of the conclusions was then asking for a continuance on this setting so we can attempt to resolve the misdemeanors.
All right, so where are we on this case?
On this case, it is, I still need time to investigate.
You'll need to get a copy of that and return the original to the clerk.
Yes, Your Honor. And then because it was a deferred adjudication, probation,
He's entitled to a bond.
that was the other motion.
All right, have you conferred with the state on bond?
I'm not on the exact amount. I informed them of the motion.
All right, so if you confer with them, and then when you all are ready to approach, just come back.
Thank you.
Cody Wade Harris. Hello, thank
How
you
you
for
doing?
dressing appropriately for court.
Thank you, ma'am.
All right, so where are we on discovery?
Good morning, Your Honor.
The one?
I believe that discovery has been completed. This morning, the state offered a new offer that I'd like some additional time to go over with Mr. Harris. I intend for the next setting, as the court calendars it, to be a plea setting. And I think that's where we're headed, Judge.
All right, how old are you, sir?
51.
All right, Ms. Ferguson, I need a 2-week reset for a plea deadline date. And state on Cody Wade Harris, I need an acknowledgement of discovery if that hasn't been completed.
We will get it ready right now.
All right, thank you. All right, you'll be back on August 7th, and that will be your plea deadline date. Once you sign the reset form, you're excused.
Thank
All
you.
right, thank you.
Appreciate it, Judge. Thank
You're
you.
welcome. Marcus Anthony Freeman. Hello, Mr.
How
Freeman.
you doing, ma'am?
I'm doing okay. Thank you for dressing appropriately for court.
Yes, ma'am.
All right, where are we on discovery, counsel?
Judge, I've just submitted a flash drive to the district attorney's office, and I've sent him an email with additional discovery that we're seeking.
And what additional discovery do you need?
It is body cam and I believe it's body cam and dash cam of the stop.
And they,
Cody Harris is 51 years old, and now he's facing what lawyers call a plea deadline. This is the legal finish line, the court saying, make your decision now or prepare for trial. The pressure is enormous. Take the deal and you avoid. The unpredictability of a jury, you refuse, and you roll the dice in open court where sentencing can be far harsher. Harris has to decide whether security now is better than risking it all later. Be honest, if you were in his shoes, would you take the safe deal or bet everything on a jury's mercy?
what's up? What's up?
Oh, no, I mean, you can talk if you want to. Sometimes attorneys don't want you to.
They have a video where they showed me like it was,
So I'm seeking that, and that's what there's no need to address that with the court.
Sometimes attorneys don't want you saying things because when you say certain things and they're in a courtroom, then people can hold that against you. So what we're here for today, I'm here to make sure that your attorney has all of the discovery, which is really all of the information that the state has that you're entitled to. There may be some information the state may have that you may not be entitled to. Do you understand?
it's now.
So your attorney is asking that he received videos, and it appears to be videos that you're saying will show certain things. So I'm trying to make sure that he receives
Thank
those.
you.
All right. Ms. Ferguson, set this for 30 days for a discovery date, please. All right, so we're going to be back on August 21st, and that's to make sure that your attorney has all of the discovery. Are you employed?
Yes, ma'am.
All right, what are your hours?
They vary. I have a time sleeping. Like I have a nonprofit, and I gave a testimony of the Holy Spirit, and they gave me my LLC license and everything. So I do a lot of church things, but it's like missionary.
Okay.
Of a NAACP mental case
Mhm.
I have up going in the courts right now.
All right, so we'll be back on August 21st to make sure that your attorney has all of the discovery he's requesting.
Yes, ma'am.
All right, you can have a seat. Once you sign the reset form, you're excused.
Thank you,
Thank
Judge.
you, ma'am.
You're
Have a
welcome.
blessed day, y'all. Thank you.
Oh, you too. Who is here on Michaela Duddy or Duddy?
We need to approach on that, Judge?
Yes.
So
I received the documentation. So just 1 second. Good morning.
Good morning.
I got you.
All right. So first things first. It's showing that she has a warrant. So that needs to be taken care of.
So my understanding from talking to clerk's office so the warrant wasn't active
Mhm.
because she's on GPS right now. So technically she's in custody. So they
See,
didn't-
you know what? They need to change that because let me just tell you, on the system, it shows that
Yeah.
she has an active warrant. But let me just tell you, in this court, when people have active warrants, before I have you, as the deputies call it, all the way, before I have you make the trip all the way, which is to the jail and everything, we try to make sure that it's correct in the system. So I'm going to send an email to all the judges and say that when someone is in custody because they're on GPS, that needs to be changed, because sometimes maybe people are not going to check the system and they'll just see that you have a warrant. They'll take you into custody and take you all the way.
Right.
Yeah.
And Judge, honestly, we didn't even know she had a setting today. I was looking into this and then saw the setting and called her and said, we need to go in because we've been working on getting this resolved with the state.
I don't have her down as a setting either on the docket. No, I'm talking about on the docket sheet. There's no setting for her on the docket sheet. What, for her to appear? The warrant was issued yesterday.
So obviously with the confusion, Judge, out of an abundance of caution, I called her. We came in. Like I said, we've been trying to work in good faith to get this resolved with the state.
Okay. So, Ms. Abrams, on this case, she doesn't have a motion to revoke, or does she have a motion to revoke? All right, so has the motion been heard? All right, so do y'all want to have the motion heard and then the court will make its decision based upon the documents that have been given to the court?
I think we need to do it that way, Judge. But, you know, I've talked to the state and
All right, so if y'all we'll go over the motion to revoke and then we'll proceed.
No, she understands the motion revoke is based on her refusal to go to DDRF.
All right.
So I think that's the only ground for the MTR.
Okay. All right. So then on this case, because it appears that she has an inpatient treatment place, DDRF takes months. And so it appears that she has a place for an inpatient treatment to address her issues. So do you all want to withdraw the motion, or you want to continue with the motion and have the court make its ruling? Because it appears that everyone wants her in inpatient treatment.
Correct, Your Honor.
And the quickest mental health treatment is actually through the Starlight Recovery Center, as opposed to waiting in the jail for transfer. If you all want to proceed with the motion to revoke, I will proceed with the motion to revoke. But however, it appears that what the court is asking her to do, which is get mental health treatment, this is it, and it will be done quicker. So do y'all want to withdraw the motion to revoke?
We will withdraw, yes, Your Honor.
All right. And so it's going to be altered and amended, and you're going to be at the Starlight Recovery Center. If you leave...
Here's where law meets compassion. Instead of revoking probation outright, the judge sends Michaela to inpatient treatment at Starlight Recovery Center. This isn't a free pass. She's under strict orders. Leave early, and she's back. In jail with a motion to revoke, but it's also a chance structured recovery instead of punishment. This shows the justice system wrestling with addiction. Is it a crime or a health crisis? Michaela's next 45 days could determine whether she rebuilds her life or spirals back into custody. Do you think rehab is the right call here, or should the judge have been tougher?
Leave that facility without permission or before they have completed their treatment, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
And do you understand you are going to have to sign a release to probation so that probation will get information on your status in the program at Starlight Recovery Center? Do you understand?
Yes, Your Honor.
She's just bringing up the waiver.
And State, is there anything else that you think she needs?
No, just the inpatient treatment, I think, is the best thing for her to resolve the issue she's having. So we're fine with this.
All right. And probation, do you believe there's anything else that she needs?
The date for her on there to be
Tomorrow.
admitted.
They said July 25th.
It's tomorrow.
Tomorrow.
Yes, tomorrow.
Yes.
How long?
They're saying 30 to 45 days. But I'm going to order that before they release her, there's going to have to be a report. So at that 45-day mark, you're not released from that facility. I'm going to want to see a report so that your attorney, probation in the state, and whoever your case manager is there, so we can figure out what would be the appropriate plan or the next step. You understand?
Yes, ma'am.
Probation, anything else?
Okay.
All right, once I have the motion to withdraw, we will release you. All right?
Yes, ma'am.
Thank you, Your Honor.
You're welcome. She's going to remain on GPS though.
Yes, I think that's the best bet for everybody, Judge.
All right, thank you.
She's not going to custody.
No, she's not. Yes. No problem. Leslie Ann Ayala.
Ayala?
And after that, it will be Gloria Carrizales and then Noah Gonzalez. Are you all ready to proceed on the motion to revoke?
Yes, ma'am.
Court is calling 2024 CR 009614, State versus Leslie Ann Ayala. Could I have parties announced for the record?
Jason Garaham for the state.
Danielle Cranberg for the defense.
And are you Leslie Ann Ayala?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? It's this document. And this is a document that states that you're on probation and that you violated certain terms of your contract with the court. Did you review that document with the state? And I'm sorry, with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Leslie Ann Ayala who was placed on deferred adjudication in 2024 CR 009614 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on January 6, 2025 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Judge, do you have the First Amendment?
No, I do not. All right, did you review the First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
All right. State, you may proceed. Thank you, Bashan.
Yes, Judge. Violated condition number 1, on or about the 24th day of June 2025 in Bear County, Texas, the defendant Leslie Ann Ayala committed the offense of possession of a controlled substance, penalty group 1, 1B-B, in violation of condition number 1.
How do you plead to that? True or not true?
We'll waive the remaining violated conditions, Your Honor.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion?
And now, the gavel comes down hard. Leslie Ayala faces 4 years in prison after violating probation. The shocking part? That's actually the deal. She could have faced up to 20 years. Notice the judge reminding her repeatedly that the agreement is not binding on the court. That hesitation you see in Ayala, the nervous shrugging, is raw fear. Imagine hearing, take this deal or risk a sentence 5 times longer. Justice here feels like a negotiation under pressure. Viewers, do you think 4 years is fair accountability? Or just the system pushing
find
her
you
into a
guilty
corner?
and sentence you up to 20 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, there is, Your Honor, and it is to grant the motion, adjudicate guilt, revoke the individual off her probation, sentence her to 4 years in the Texas Department of Correction, and the state will be taking into consideration the new number 1, possession less than a gram. That case number is 2025 PF 24568. And with the previous prosecutor, an additional case will be taken into consideration, 2025 CC 007573, which was a reckless driving that happened before she was placed on probation.
All right, counsel, is that the agreement?
It is, Your Honor.
Are you asking the court to follow this agreement, counsel?
We are, Your Honor.
Ms. Ayala, are you asking the court to follow this agreement?
Agreement. Yes, ma'am.
All right, do you understand what's going on here?
Yes, ma'am.
The agreement is that your probation be revoked and that you be sentenced to 4 years in the prison.
Yes, ma'am.
I do not have to follow the agreement that has been reached with the state and your attorney because this is a contract with the court. It is not with them.
Yes, ma'am.
Do you understand?
Yes, ma'am.
So is there anything that you don't understand that's going on here today? So instead of giving you 4 years, I could sentence you up to 20 years in the prison. Do you understand?
Yes, ma'am.
Now, this agreement that they've come to, do you want me to follow that?
Yes, ma'am.
All right, does she not know what's going on?
I did explain everything with her, and that is what she told me she wanted to do. I think she's just nervous to be before the court, Your Honor, because she knows that you aren't bound by the deal.
All right. So you understand that they're asking that you be revoked and sentenced to 4 years in the prison?
Yes, ma'am.
Do you want me to follow that?
Yes, ma'am.
All right, so I don't understand what's with the hunching of the shoulders, like, I don't know.
That's fine.
All right, so I'm gonna have you go back and talk to your attorney and you need to decide whether you don't want me to follow that or do you want me to do what I think it's appropriate in this case, which is more than 4 years. So you can talk to your attorney.
Yes, ma'am.
Thank you.